Hello, and welcome to my talk on copyright, higher education, and COVID 19, a legal perspective. I am Julius Fleschner, and I am giving this presentation as part of the Higher Education Leadership and Practice EDD program at the University of North Georgia. So today we're going to talk about a couple things. We're going to go over the genesis of U.S. copyright law. Fun fact, it's a little older than you might expect. We're going to explain some of the important facets about copyright law, looking at exclusive rights and fair use, and giving just kind of a basic overview of what these things are and how higher education institutions can operate within those frameworks. We're also going to look at copyright and how it has been applied during the COVID-19 pandemic. There have been some very interesting developments on this front that I think really do bear discussion and review, particularly when we're looking at how do we lead institutions through an uncertain future. And that will culminate in some recommendations for higher education institutions in the future. So let's jump in. The genesis of U.S. copyright law. Here's a quote from the U.S. Constitution. The U.S. Constitution has some enumerated powers for Congress, meaning that it specifically lists out Congress can do this. In that section, Article 1, Section 8, it says Congress has the power to promote progress of science and the useful arts by securing for limited times to authors and inventors the exclusive right to their respective discovery, to their writings and discoveries. This comes from the U.S. Constitution, and Supreme Court cases and laws have been built off of this very, very short phrase in the Constitution. This is called the Copyright Clause. So here's something interesting about the Copyright Clause. When it was presented at the Constitutional Convention, right, so we have this thing where George Washington is chair and we've got James Madison and Alexander Hamilton and all of these folks together in a room discussing what should the framework of the country look like. They presented this clause and approved it unanimously. This is wildly uncommon for the things that happened in the Constitutional Convention. Usually debate raged in that room. This is one of the very few instances where it was just unanimously agreed. Perhaps this is because there was a common understanding that copyright was important and what it was amongst the framers. This stems from English law. Like, there is precedence in English law for copyright that we're going to talk about in a moment. It's also worth noting that several states had shared language about constitution in their own state constitutions. They said to encourage men of learning and genius to publish their writings. So, little gendered language there, but we'll say this was the 18th century. But that language was common in this time period. Going back further, just to help us understand why this is in the U.S. Constitution, the stationer's copyright is the first genuine kind of law about copyright stemming from England. This is from 1556, and it was a charter given by Philip and Mary to a company called Stationer's Copyright. And Stationer's Copyright maintained a list of books that were authorized. And if they found a book that was not authorized, they could just go ahead and burn it. That's actually what the charter says. They would look for this stamp in the book to determine if it was an authorized book or not. This is largely seen as a method of control from the crown, meaning that books couldn't be produced that the government didn't agree with, and the private company was the mechanism through which this occurred. This was updated about 100 years later, more than 100 years later, by the Licensing Act of 1662, which made it a criminal act to print anything that wasn't registered with stationer's copyright. This moves it from a private company enforcing a semi-private law to a government law and a criminal act. All of this was eventually put into the Statute of Anne. Now, this is the primary genesis for copyright in the United States. This moved copyright from a private registry involving a private company into a public registry. Here's a little piece from the act, and if you notice, the language looks a little familiar. An act for the encouragement of learning by verifying the copies of printed books and the authors or purchasers of such copies during the times therein mentioned. A little older language, but we have that, an act for the encouragement of learning. This act had copyright last for 14 years, and then it could be renewed for another 14 years. After that, it was fair game. You could copy as many copies as you wanted. Here we have a proto-public domain, and we have limited copyright terms. 28 years was the max you could have the private right to your work. So that was a knowledge amongst the framers. And when the first Congress met, the second law they passed was the Copyright Act of 1790. And this act, first line, an act for the encouragement of learning. We're starting to see that common thread throughout all of these copyrights, or all of these copyright laws. This was almost a copy of the Statute of Anne. 14-year period, and you could renew it once. From these early beginnings of copyright in the United States, we see an ever-marching trend towards lengthening these time periods. Here we have that 1790 Act, which was that 28-year mark. Here we have an act from 1831 that made it 41 years. Here we have 1909, which made it 55, 56 years. And we've just marched on and on and on. This has an effect of people writing material and having their copyrighted work last for a very long time. We currently are the life of the author plus 70 years. So if you have someone write their book in their 20s and they pass away in their 70s, you now have a period of 50 years plus 70 years before that work can be freely copied. There's a raging debate in the field of copyright discussing, does that actually promote progress and learning and science, or is that just a way for people to make money off of work they have written? The most recent, well, not the most recent, but the most substantive change in copyright law in, let's just say, the last 150 years is the Copyright Act of 1976. This act extended the copyright term to the author's life plus 50 years. Like I said, we're at 70 now, so this was amended shortly after. This particular act explicitly laid out the exclusive rights of copyright and fair use. These are all in Title 17 of the U.S. Code. It's very easy to look up. All you got to do is go to Google, type USC Title 17. This act is so unique in that it codified fair use for the first time. So before this act, fair use was something that just existed in jurisprudence. Common law, court rulings, precedents existed, the court had to uphold it. This was the first time that the Congress saw fit to move it from the realm with the courts into the realm of the law of the code. This law gives you 5 exclusive rights. So it gives people who create material the exclusive right to reproduce, derive, distribute, perform, and display their work. This is the actual language from the bill. One of the more maddening things is that they took a perform right and put it in two different places. But there we are. Worth pointing out, this is the code as it stands today. And if you notice, it makes use of the words like phonorecords. This, I think, is going to stand for some updating in the future. But here is how it stands now. The Code and the Copyright Act of 1976 also lays out explicit criteria for fair use. So something you need to know about fair use. You can only claim fair use after you've been sued for copyright infringement. So you can't just take a portion of a work, put it in your course in D2L, and say, oh, it's education, that's fair use. Doesn't work that way. You would have to get sued and make that case in front of a judge, at which point you've now engaged a lawyer and you're burning through your institutional reserves. So you want to be careful claiming fair use, but it's a powerful tool if you ever need to defend yourself. If you ever do get sued, the judge is going to consider these 4 factors. This is called a 4-factor test. They're going to look at the purpose and character of the amount of the work you've used. They want to see if it's a commercial work, if it's fiction, if it's nonfiction. How are you using it? Are you using it for educational purposes, or are you using it to sell additional works? The nature of the copyrighted work. Again, is it fiction or nonfiction? Are you using things like facts from a work that you've paraphrased, or are you just copying the entire text of a book and putting it online? The third factor is the amount that you're using, right? So there's a general rule of thumb that you should stick to about 20%. And that comes from cases where people have argued that their use of the work was fair. You want to keep it to as minimal as possible to get your point across. And finally, the 4th factor of fair use, and this is the one that the courts weight the most heavily, is the impact of your use on the potential market value of the copyrighted work. So if I went out and I took the 3rd Harry Potter book, which in my opinion is the best Harry Potter book, and I copied it, and then I printed it, and I bound it, and I sold it for $5 a copy right next to the Scholastic copy that's selling for $25, I've hurt their market value. That would not be considered a fair use. However, if I'm just pulling a chapter from the book in the context of a class talking about imaginary characters in literature, I'm probably not harming the sales of the book. I'm using a portion of it to illustrate a point in the context of a class. That would probably be considered fair use if it were in front of a judge. The Teach Act of 2002 also has big implications for fair use. As the world marched on, from 76 to 2002, online education became much more prominent. We had K-12 schools and higher ed both looking at delivering and developing online classes. So this act had Congress look at expanding fair use and making very clear distinctions on what is fair use and what is not in the educational context. Worth pointing out, though, you would still need to be sued, and you would still need to affirmatively claim fair use. So the Teach Act, in order to make use of these exemptions for fair use, an institution would have to be educational, nonprofit, or government. The content has to be locked down, meaning I can't just email it to my students. The institution has to have a copyright policy, and it has to encourage compliance with that policy across the board within the institution. That seems like pretty good and solid administration, but this is one of those little carrots that the federal government uses to help institutions move in a similar vein. So, within this backdrop of copyright law and the 5 exclusive rights and fair use and the Teach Act, COVID-19 happened. During the pandemic, or early in the pandemic, many information providers reached out to institutions and said, hey, if you want a free trial to get your students through the spring semester, we'll go ahead and do it and make it open and available to them. They also made their material free online for anyone. The vendors, meaning the information publishers, the people who own the copyrights, were pretty fair to libraries and institutions, and they've generally worked with us. JSTOR and Cambridge University Press are both examples who really stepped up and opened up their databases for public use. RedShelf and VitalSource also opened up textbooks for students to use in this moment. Other organizations also opened up their material, but the way in which they did that is a little more controversial. One example of this is the Open Library from the Internet Archive. They use a model called controlled digital lending. Controlled digital lending is a legal theory that posits that libraries can go out and scan physical items, make them available online or digitally, and loan them on a one-on-one basis. So, for example, I can go into the library, I can pull Abby Hoffman's Steal This Book off the shelf, I can scan it, and then I can loan it on a one-by-one basis to patrons. So if I have a digital patron who wants a copy of the book, wonderful. I'm going to loan it to them for 28 days. I'm pulling the physical book off the shelf, so no one can borrow it until the student is done with it. And then when they're done with it, I put it back on the shelf. If someone wants it in that 28-day period, they go on a waiting list. Now, this is a little bit of a fringe fair use theory, if I'm honest with you. Controlled digital lending hasn't been tested in the court, but I suspect it's going to be. Because the National Public Library during COVID removed the wait list. They no longer had people wait on a list to get a book from the National Emergency Library. If they had a copy and someone requested it, or if they had a scan of it and someone requested it, they just sent it to them. There was no one-to-one ratio. In light of this being part of a public health emergency where libraries had to shut down and we couldn't really access our stacks, many libraries supported this. Amherst, Brown, Dartmouth, Duke, Emory, Grinnell, MIT are just some of them. If you notice, many of these are private institutions. But sure enough, they supported this. Their libraries and their institutions have signed the letter of support for this action. Publishers were not pleased with the National Emergency Library. They have written several strongly worded letters to the Internet Archives, and they have now brought case against the Internet Archives. I think this will set some precedents for controlled digital lending and fair use as it relates to a public health emergency. I also think this is going to give us clear guidance on CDL going into the future. Is this something we really can do, or is this something that's stretching it too far? The courts are going to have to weigh in here. And this has all the makings of a Supreme Court case because this will set precedents. So, some recommendations for HEIs given this landscape of copyright, fair use, pandemic use, the whole thing. Step one is determine your risk level. How risk adverse are you? Are you very conservative in that you don't want to take any risks at all? Or are you very risky and you're willing to push the boundaries to innovate? That's going to determine your general course of action here. I can see many institutions coming out of the pandemic getting behind controlled digital lending. However, this is still kind of unproven in the courts, and so it does weigh a little more heavily towards the risk side on the spectrum. The second big recommendation for HEIs is make a copyright policy. Write it down, make it clear, stick to it. Educate your community about your copyright policy. This is required if you choose to take advantage of the special features or the special fair use features in the Teach Act. However, it's just darn good administrative practice to have a policy and stipulate what you're going to do. You're going to reduce your liability anyway by doing that. And third, engage your library faculty. The library is the mechanism through which the institution provides the subsidy for information. Go to the library and ask the library dean or director or the acquisitions librarian what their thoughts are about educating the community about copyright. Many libraries have liaison programs where they're paired with their teaching faculty colleagues. And they can go and they can work with them and pull alongside them as peers to help them understand copyright and avoid using uncopyrighted material in their classes. This is a prime role for the library to serve the institution. And with that, there are my references. I thank you for listening to me and my musings. We have gone all the way from 1557 to 2021. So I hope that was enjoyable and you learned some interesting facts about copyright and you came away from this knowing a little bit more with some solid recommendations in hand. Thank you all.